welcome to this special edition of Let's Talk Law. I'm Anusha Soni. With us today is a very special guest, Mr. Vikas Singh, Senior Advocate from the Supreme Court of India, somebody who's also been the ASG to the Government of India from 2005 to 2008, also served as the Supreme Court Bar Council SCBA President, and has had an illustrious career at the bar. Represented some leading clients in some matters which have dominated the public discourse. Today he is here with us to discuss multiple issues pertaining to Indian Constitution in the Modi era, and very interestingly, the sweeping changes that have been suggested to the Advocates Act. Sir, thank you so much for sparing time today. Thank you so much for being a part today. I want to begin, with the most recent topic which is being discussed right now. You've been a president of the SCB in the past also. You're very well versed of how critical the role bar plays when it comes to Indian judiciary. What are your thoughts on the changes which have been proposed to the Advocates Act?
So most of the changes that I saw are related to the functioning of the Bar Council of India.
Yeah.
So Bar Council of India, probably because of the way it has been functioning in the recent past, the government feels that there is some change required in their functioning. So I'd rather not comment on them, but there is a very important change which, according to the lawyers, will not be acceptable at all. And which is the one which says that for your enrollment, you should not be even charge sheeted for an offence of more than 3 years punishment. Now, it's so, quite this thing that when Parliament itself permits even charge sheeted of serious crimes, even of, heinous crimes like murder and rape, etc., dacoity, to be elected to the Parliament, they don't want a professional to continue as a professional just because he is charged of some offence. Now, in the country that we have today, and without the police reforms happening, it's very easy to set up a case against anybody. We saw recently a case being, magistrate ordering an inquiry, a criminal case as registration against the Chief Justice of India, then Chief Justice of India. So that's how easy it is to, start a criminal case. So if it is so easy to start a criminal case, then to say that you can't practice as a lawyer because you are charge sheeted in some, most of the time false case, that is something which is not acceptable at all, and I'm sure the government will be well advised to withdraw that part of the amendment and ensure that it doesn't come into the statute. Otherwise, it will be a huge unrest in the entire country.
So two aspects I want you to shed some light on. First is the fact that there would be government representation at the Bar Council of India. There would be 3 members. That's what's been proposed, still being proposed. Does that amount to interference with the independence of judiciary? Because that's an argument which is being made by certain quarters.
Well, I don't see in a multi-member body where the government nominees, without having any primacy in the functioning of the Bar Council of India, will affect the autonomy of the Bar Council of India in such a drastic way. Ideally, it should not happen. I feel that it should not happen, but it's not something which is so fundamentally affecting the functioning in the Bar Council that merely because 3 nominees come in out of the multi-member body of more than 20 people, it will erode the independence of the body. So and as it is, the way Bar Council of India even today is functioning, it is literally functioning as the limb of the government. So I don't see why they should have such a huge objection to government nominees coming in without any special powers.
That takes me to the point where there's an argument that most of the bar councils are political in nature, and is there a need to regulate them? That takes us to that question.
So bar councils, the way they have been functioning in the recent past, I have not seen ever bar council taking up any cudgel with the government, on any issue either of national interest or of even lawyers' interest. They basically follow the line of whatever the government wants them to do. So suddenly for them to become so proactive at this stage when the amendments are being sought to the Bar Council of India is a little surprising, because they have never been opposed to whatever the government does. So I would expect the Bar Council of India to be a voice of the nation and to take up, for instance, if there are some bills which need to be, challenged, or if there are some legislations which are not good for the country, to oppose them and to, make out a case that, make out a voice of the people for deliberating on them. So they have not done that so far. They should ideally. If they do that, probably then they would be said to be more independent and autonomous.
So, the legal profession in this country, as across the world, is going through a transformation. There is so much talk of foreign law firms now interested to come to India. There's also a suggestion in the changes and amendments that have been proposed that the regulation of foreign law firms, if they were to enter in India, would be done by the central government. What are your thoughts on that?
Well, here also, foreign law firms or foreign lawyers, like in the medical profession, it is all on reciprocity. Now, if the foreign countries don't allow our lawyers to go and practice there, or our law firms to work there, I don't see why they should be permitted to practice here. So, if it should only be firstly on reciprocity. So, the country which permits our people to go there, they should be permitted to come here. Now, whether that is done by the central government or by the Bar Council of India, that should be the central theme of permitting them to come in. As of now, the Bar Council of India has framed some schemes, and foreign law firms can have offices here, but with a very limited mandate. And the limited mandate is that they will not, take on clients directly here for dealing with Indian law. They can only work, supposing it's a Australian law firm, then they can help firms here to deal with whenever there is a case involving Australian law involved. So that should be, that is so far. And another reason why this should not happen in India is that even if it were to be reciprocity, the restrictions on Indian lawyers is far more than what is there on the foreign lawyers in their own soil. So for instance, we can't advertise, we can't even have a website. All this is, punishable under the Bar Council regulations. So if you can't advertise, and whereas a foreign lawyer can advertise for his work, then to permit him to come here will also create an unequal field.
Yeah.
So all those issues also will have to be taken up. It has to be done under a very consultative process. And I would ideally feel that if Bar Council were to be responsible, then this should be ideally done by the Bar Council of India only.
Before I move on to another issue, once again I'll reiterate the question. Do you think that the present Bar Association, whether at the district level, whether in the High Court, in the Supreme Court, in the present form, require any regulation? Because that's what those draft changes are opening the discussion to. That, there's some kind of regulation which is required, there's some kind of consultative process with the government which is required. And the present stream of changes proposed by the government, do you see them in the right direction?
So I don't think there is any change in the control over bar associations in this amendment. The changes are on the functioning of the State Bar Council and the National Bar Council. And I don't think they should ever interfere in the functioning of the Bar Association, except probably for having a model rule which normally bar association should adopt, which is, like for instance, I don't know whether recently you are aware or not, in the Supreme Court Bar Association, the judges wanted, there was a petition being heard, and they wanted women to be represented, having a certain percentage in the Bar Association. Now that was put to vote and all voted down. Ultimately, the judges by a judicial order provided for that. I don't see why it should not be there. But in a male bastion where the number of females are so few, as of now, of course the numbers are slowly increasing. I don't see why certain percentage or certain positions should not be reserved for women lawyers in the association. So that could be part of the model bylaws for the association. And otherwise, I don't see the government or the parliament trying to interfere in the functioning of the bar associations.
Now that you've already touched upon this issue, there is much discussion about the representation of women in judiciary, at the bar and on the bench. It's a heartening trend that we are witnessing in various law colleges across the country, that the number of female law students or the number of graduates from law colleges has gone up sharply. But there's also a high attrition rate that happens in the profession, say after 8 or 10 years, due to various reasons, factors and responsibilities. Do you see the profession really evolving to accommodate more women? Or how is it that veterans like you think that this profession can be more friendly to women? You said it's a male bastion, rightly so. But can we make it more friendly?
So, women by their very nature of their, I would say the lifestyle that they have, of getting married and children and maintaining a family, litigation requires a lot of hard work in the initial years. And it's only when you, establish yourself that you can do a more peaceful life. Otherwise, it is a very, very hard. And that's the time when these women lawyers, they go through childbirth and they have to start a family and they really are not able to cope and they are, there is attrition. But I personally feel that if you want more women to be, joining the legal profession, then the first and foremost thing is to make more judges. Now, interestingly, when you talk of the lower judiciary, the percentage of women in the lower judiciary is about 35-40%, which is what you would expect to have in the legal profession. Now, why is it 35-40% and why it is below 10% in the higher judiciary? The reason is very obvious. The reason is that selection is on merit. So women are able to compete there. This selection is not on merit.
Yeah.
Now, if you want to have a collegium system where the judges know whom to elevate, then only they will elevate. Just imagine the plight of a lady lawyer. For her to expect her to go and lobby for herself and become a judge.
To be visible everywhere
so
is very
that becomes very, very difficult. And that is where I feel that the system has so far failed as far as now the erstwhile Chief Justice of India, Justice Chandrachud, said we don't have enough women in the amongst lawyers to elevate, which is actually not correct. But even if I assume that to be correct for the sake of argument, there are definitely large number of women in law firms. And I don't see why they can't be elevated to the high courts directly. So you have to look for them, the right amongst them. They have also done good amount of work. They also have a very decent practice. And their knowledge of law cannot be in any manner said to be any less than a litigating lawyer. But you don't want to open up your eyes to see where all people are there. And when I say law firms, I mean even men lawyers. Why not men lawyers also? If they're doing well in a law firm, why should they not also be picked up? Why do they have to roam around in a court of law to be considered as eligible to be elevated? So that's where this mindset has to change. And unless that mindset changes, women's representation in the higher judiciary will be a difficult thing to achieve.
But sir, how should we discuss the Modi years of Indian Constitution? How Constitution has evolved in the Modi era? How do you see it?
So I would say that the Constitution has firstly proven to be a visionary document. And when you see our economy, when initially the economy started with Jawaharlal Nehru and when there was not many people wanting to invest in India, or there were not many investors for the infrastructure sector, we required the public sector. And in the 90s, then just Mr. Narasimha Rao felt that this is time, and Mr. Manmohan Singh felt that this is a time to open up the economy because there was sufficient number of people who had, were there to invest. You came up with the private sector, and Modi has taken the private sector to a different level. So I don't see the Constitution has ever been a hindrance, firstly, in development of this country. And as far as the Constitution is concerned, I don't think there is any drastic change which has happened, which will, be called as a Modi era change, except for some laws that have been brought in.
Sir, we were talking about judicial appointments, and I very briefly want you to touch upon that because you've seen that phase, that entire NJAC period, that battle being fought at the Supreme Court very closely. Has the process of judicial appointment, especially to the High Court and Supreme Court via collegium, has it really been streamlined? Something that was discussed earlier.
So, interestingly, NJAC had two limbs. One limb was whom to appoint, and the second limb was who will have the authority to appoint. The whole discussion happened on who will have the authority to appoint. They didn't want the primacy of the Chief Justice of India to be diluted by having a committee which will have more government nominees than the collegium members. And that is why NJC was struck down. But the system of having an eligibility or having a panel or having names, coming up for being considered for elevation, that nobody faulted. And I, in fact, when Mr. Rijiju was the law minister, I made a bill to regulate the collegium system, and I said there should be a system by which the good names in the system are considered. That is not happening, unfortunately, today. What is happening is, unfortunately, can be said to be full of nepotism and favoritism, because the collegium members are only elevating people whom they see in front of them or whom they know. Now that is a very, very small area of, looking at names. If you see people whom you don't see in courts or whom you don't know, probably the area will get, and classic cases of ladies in law firms. So if the collegium is not ready to, so if you've taken authority on yourself to a point and you say, I will decide, then it comes with a huge amount of responsibility. Like for instance, Supreme Court lawyers.
Yes.
Supreme Court lawyers don't go to the high courts. Why can't they be considered for? And I'll tell you, the last 40, 50 years, whenever a Supreme Court lawyer has gone as a judge in the high court, he's done exceptionally well. So I don't see why Supreme Court lawyers as a matter of right are not being considered. Why somebody is not looking at the names in Supreme Court, practicing from a particular high court and consider him for elevation to the high court. So unless you open out and look for names yourself and try and see that this is a good name, he could be a good judge, you have not done the justice that you're supposed to do to this appointment process. And that is where the effort is lacking completely.
So you insist upon that the pool should be wider.
Always.
Always, and that will be more inclusive for different people. So that takes me to the interesting concept of how the Supreme Court that you have observed since 2013. I remember NJC was one big battle. Modi government was sworn in. It was the first term of the Honorable Prime Minister. And after that, we have seen series of big decisions that have been taken by the government, whether it was Article 370, demonetization, EVM issue, the electoral bonds case. Everything came to the Supreme Court like it does. How do you see the last 10 years? And how has the Indian Constitution really evolved, if it has, in these last 10 odd years?
So the last 10 years, according to me, have been, not good years for the Supreme Court, because we have not seen many Chief Justices wanting to take on the government or doing anything which is not palatable to the government, and which is not a good thing for a healthy, judiciary or for a healthy democracy. And there has been, Chief Justice after Chief Justice who's been trying to toe the government line and insist on government nominees being elevated to the Supreme Court, and those government nominees, the way they behave as judges in the Supreme Court is sometimes a lot to be said about them. I'll not name anybody in particular, but there are several of them. So this is something which I would say the future Chief Justices have a tall order to restore the faith of the people in the institution. Because if the common man feels that they will not get justice if they were to claim anything against the government, then it's not a very happy state of affairs. So I think that has taken a big beating in the last 10 years in the Supreme Court.
But to be the devil's advocate here, whether it was the elevation of Justice K.M. Joseph or the electoral bonds case, I think right before the elections it was a huge setback to the government. One of the key arguments that has come from the side of the government, or the people who talk on behalf of the government, has been that the Supreme Court has not really taken kindly to the reforms that were done by the government. Do you agree with this kind of argument?
So which reform are you talking? Are you talking about the
electoral bonds case?
So electoral bond, according to me, was a judgment in favor of the Supreme Court, in favor of the government.
Okay.
When you say that the whole bond scheme was unconstitutional, why do you not ask the political parties to return the money? If this money was to be given in anonymity, and the money in this scheme was not taken, constitutionally, then you return the money. If somebody still wants to pay money with disclosure, he should be permitted to give. So I don't see this judgment. I mean, there is a public perception that the electoral bond case, the Supreme Court has given a blow to the government. On the contrary, the electoral bond case permitted or justified the money which they had accumulated for being retained by these political parties.
Yeah,
And
it wasn't really returned. There was no audit.
There was
of
no
any
order to
funds.
return the money. It should have actually been returned to all the political parties, all the people who had invested in the bonds. All political parties should have been asked to return the money to the people who invested. And if they still wanted to give back that money with disclosure, they should have been permitted to do that. But how do you keep the money and say that no, this whole thing is unconstitutional?
Interesting take. I will ask you a direct question here without really beating around the bush, which is that opposition parties argue. This is one of the key arguments of the opposition parties in this country. In fact, they went to the Supreme Court also. I remember in that petition where the opposition parties came and said, look, investigative agencies are being misused, ED, CBI. They say constitution is in danger. Has it been in danger in the last 10, 11 years? Are there any changes to the Indian constitution according to you that have been made that should not have been made?
So, according to me, the one wrong that the Modi government has really done is the notification of 2018, which permitted 11 organizations to do snooping, because the very section of the Telegraph Act which they used to permit these organizations to do snooping was actually a section meant to do individual snooping. So, for instance, if I know that a person X is having some links with the underworld or is doing something nefarious, a specific permission is given to snoop his line. That section was used to give a power to the agencies to snoop on people. Now, what has happened because of this snooping? Now, what has happened is that if you want to only tap the phones of opposition political parties and not tap the phone of your own political parties, obviously you will get the scam which is happening there and not get the scam which is happening in the ruling political party. So that is where this aberration takes place. But at the same time, the political parties of the opposition who say that there is a danger to the constitution because they were doing wrong and because the ruling party also is doing wrong, so they should not be hauled up till they are also hauled up is again completely, it can't be
a tenable argument.
Justified under any circumstances happening.
And what about that argument of constitution being in danger?
So constitution has never been in danger according to me. Constitution has always stood the test of time, and constitution according to me, and that's why I started off by saying that it is a very visionary document. It has proved over a period of time. It has weathered all kinds of storm. And it has remained untouched. So I wouldn't say that the constitution is in danger. Rule of law may be in danger, but not constitution.
Sir, I want to take last 5 to 7 minutes and talk about your journey as a lawyer. You've often told me how you've been the first generation lawyer, how you started in the profession. A lot of people watching this podcast are young law students who want to make it big in law, who don't really have mentors and are still trying to figure out what to do. They may come from smaller towns, smaller cities in this country. Very briefly, if you'd like to sum up your journey of 35 years, how you started and what helped you make it big in the profession.
So firstly, I tell this whenever I go to a law college and talk to these youngsters, that to become a lawyer or to succeed as a lawyer, you should understand the pain of your client and consider that pain as your own. So that is the first requirement. And that requires your empathy. The second requirement is that every pain doesn't have a legal answer.
Yes.
There are a lot of troubles that you may go through may not be justiciable. So you have to find a justiciable way of putting that pain across, which can go to a court of law for being addressed. That requires your education, your how much law you've studied and how you understood the law and how you interpret the law and how you are able to translate the statute into a person's problem. And the last will be, of course, combining these two together and then trying to get him justice. If you are looking at trying to solve the problem of your client, and if you're able to find a legal way to do it, then money is a byproduct in this profession. I always say that you don't have to work for money. I must have initial years I hardly earned anything, and people who
that's the problem with most lawyers.
Most lawyers it happens.
That in the initial years.
But initial years, you get today the youngster is today's generation is rather very restless. They want quick money. And in the process of earning quick money, they forget the basics. And then they, somehow get...
Would you like to remind the basics? This is the age of artificial intelligence.
So the basics is, of course, that firstly, it's a noble profession. So you have to, if you look at the pocket of your client, if that is your first, look at the client, then you're not in the right profession. You are in the right profession if you look at the problem of the client. Every client who comes to you, he literally, transforms or he transfers his problem onto you. And then he's sitting at home and you carry his problem till the matter is argued in court and you get him relief. So you should have that empathy to understand that person's problem and take it as your own. And then give it a legal shape. And if you're able to give it legal shape, then the rest according to me just follow. So if this you're ready to do, and if you're ready, and there is a lot of hard work. People tell me, should I start in Supreme Court or should I start in the High Court?
You started in Supreme Court.
I started in Supreme Court. So the answer to that is that if you are ready to do a overnight thesis in a new subject of law, overnight, I mean in 12 hours or 14 hours, then you should be in Supreme Court. But if you want to do only one subject or you don't want to get into, because Supreme Court every day
everything comes to Supreme Court.
Yes, everything. And no lawyer can say that I'm practicing only this or that. He has to practice everything. So if you have to practice everything, then to be a master of all is a very difficult task. So,
Can AI change the dynamics of the legal profession? How do you see these technological interventions?
So AI will definitely help in, getting you faster to the problem, but AI will never be a replacement because there is always a human interface required to interpret AI also. And if you go by AI's simpliciter, AI can do a normal routine drafting for you, a normal lease rent, etc. But the lease rent also will have certain nuances which the human interface only will be able to do, considering the exact property being put on lease and considering the landlord and who the tenant are and what their aspirations are in that document. So it can never take over anything, but definitely it will make things. I remember when I started in the profession, there was no SCC online, etc. And we used to do the normal textbook route of going to the textbook and seeing the section.
So what I hear from a lot of friends is that the future generation of lawyers, the recent graduates, there's a huge problem. They don't read, they're not reading enough, they're not writing enough, also thanks to AI, because you don't have to write that basic stuff. But in law, in my limited understanding, it is the core of it, reading and writing.
Absolutely.
Yeah.
So when I became an ASG and I had to do much more diverse matters than what I was doing earlier, so I did even matters which I had never done in my life. Then this, by which time, that was in 2005, by which time this SCC online, etc. had come. So doing a search became much easier and faster. That advantage definitely a youngster will have. But making the search faster will not, do the search itself. You'll have to still look into it and see the nuances. If I want to see a particular section and how it has evolved, at least I'll have to see the journey of that section, how it was interpreted earlier, why it was interpreted differently later, what was the reason for the new interpretation, etc. So that you have to understand and get into. If you don't get into that, you have not done your bit.
You've observed the new generation of lawyers at the Supreme Court, a lot of young folks coming there. What are your thoughts on the new generation of lawyers?
So fortunately, as compared to my time, now good students are coming to law. In my time, I would say in these 80s, only people who didn't get any other job used to come in law.
You're saying it very candidly.
So now I see, bright students of families wanting to take law as a profession and taking up law. So that's a very big change, and I'm sure that will help the future generations to improve on the system that is already there and see that this profession goes to a higher this thing.
Yeah. So you believe that the future generation of lawyers, because these are brighter students coming into being, has much to offer to the profession.
That's absolutely.
But the pitfalls remain the same.
Pitfalls remain the same.
Pitfalls remain the same.
Hard work is hard work. There is no substitute.
There cannot be AI for hard work.
There can be no AI for hard work.
So thank you so much for your time. It's been a pleasure
talking to you.
Thank you.